67 alleged appellants, and I'd like to know how we're going to deal with that issue. Are all 67 appellants going to be presenting a case? I don't like doing that. I don't want to stifle the presentations, but I'd like to know who will be presenting for the appellants. And your name is? Ms. Jordy, let me get the spelling of your last name. Are you an attorney, Ms. Jordy? I don't know what that means. Okay, got it. And spell your last name, please. Thank you. And sir, what is your name? Thank you, Mr. Hauser. You are the gentleman who actually filed the form application on behalf of the appellants. Okay, and are there any other appellants that are going to speak? Yes, ma'am. Villegas. Anybody else? Yes. You're going to have to spell your last name, Sandy.
Z-U-S-C-H-L-A-G.
Thank you so much. Anybody else who is going to speak for the appellants? Okay, so Mr. Lawrence, I see that you are here. I saw you a minute. Good morning, sir. You are representing the party opponents, correct?
That's correct.
For the record, Lawrence Wells with for the party opponents who are consensus and planning agency agents for the city of Albuquerque. I note that, and I apologize, I just read your arguments, Mr. Wells, this morning, and I note that you've stipulated that there is a notice deficiency and that you're recommending a remand. That was my original thought when I read the appellate record, folks. So now that we are all here today, let's use this time wisely. Mr. Wells has recommended, and he stipulates to a remand, and he stipulates, as a matter of fact, there are certain folks, certain property owners that did not get notice of this matter. I don't know whether they have actual notice, that is whether or not they actually participated in the hearings or actually knew about the application. I don't know that, but for purposes of this hearing, Mr. Wells has stipulated on behalf of the city that notice was not completely accomplished, and he would recommend a remand. When I find that notice has not been accomplished correctly, I remand it back to the body that originally heard it. So I'd like to know from the appellants whether or not they would stipulate at this point to a remand, because if so, I don't want to put my thumb on the scale. I don't want to make an advisory opinion regarding the substance of the appeal. It would just go back to the EPC to be heard as if it wasn't heard again. Or actually, let me retract that. It will go back to the EPC and it will be heard again, and they can choose how to hear this matter based on their own rules. So, Ms. Jordy, what is your position on this?
The four of us speaking here today don't take a position. We would just defer to the hearing officer. We do believe that there are still issues that we asked to be heard today that would not be cured by just remanding on notice. Our appeal is based on several deficiencies by the EPC, not just notice, although we do appreciate.
Is that the allegations regarding the conflict of interest?
The quasi-judicial, we would like to address the, there are some preliminary matters I'd like to put on the record, but we would also like to address the essentially disregard that the EPC had for opponents to the stadium build. And, you know, at this point we've come, I think, so far that making those arguments now would be appropriate.
thank you. Mr. Hauser,
Yes, sir.
what is your position on a remand?
I would then support and echo the comments that Ms. Jordy made, that we've got a lot of information that would be presented today that would be able to address some of the deficiencies and items that we've outlined for the EPC and for yourself, sir. So we recommend that, my recommendation is that we proceed to be able to deliver the information that we have so it can be duly looked at.
What about the remand, though? And did I make it clear the purpose for the remand? I mean, Mr. Wells stipulates again
Yes.
that there was a notice deficiency.
That is correct.
Okay, so, I mean, I can tell you, I will send it back to the EPC because I don't like due process violations. Whether it was intentional or not is irrelevant to me. It's a deficiency that needs to be corrected. And so a remand is appropriate. I don't want to put my thumb on that scale for the EPC. I don't want to tie their hands with making any recommendations to the city council regarding the merits of the appeal. I mean, doesn't that make sense to you, that the EPC should consider these issues again as if it never was appealed?
I agree with you in part, but the way the delivery will happen with EPC is different than what we are prepared to talk about today.
I don't have control over how the EPC manages their caseload or how they hear cases. I only have authority delegated to me by the city council to make recommendations regarding the merits of the appeal under the IDO.
Understood. Can I just confer with my colleagues on what we want to do?
While you're conferring, I want to ask Ms. Villegas? Yes. Ms. Villegas, can you come up a little closer so we can get you on the record? Ms. Villegas, what is your position on this?
I guess I have a question when you say remand, just based on the notification. So are you saying then it goes back to the EPC and they hold another hearing through the EPC again? Would they have to go back and do the notification to the neighbors who did not receive notice?
That's a very good question. Yes. Yes, it is essentially restarting the matter.
Okay.
As if it didn't occur. And I hope the EPC would do it that way rather than use the evidence that's existing in the record. Because theoretically, a remand for a notice deficiency means that there are certain people that didn't know that this occurred. Right. And so they would need to have an opportunity to participate. I mean, it's just an opportunity. If they don't want to participate, that's their right. But theoretically, they would have an opportunity to participate anew like everybody else would. And so you would have an opportunity to participate as if it didn't occur again.
Oh, okay.
Does that answer your question?
Yes.
So what is your position on that?
My position is I do agree with a remand. However, I know there are other points, but if we are able to technically start over, meaning that people will be able to talk like whether they're opposed or for this, right? I mean, when you say have like a new hearing, does it mean it just starts over, like we just have it like we didn't have before? So they're not going to take what's already on their records and use that?
Yes. Now, I will ask Mr. Wells to explain his version of what he considers a remand would look like. To me, it would look like a brand new hearing, and certainly I can include that in the instruction. That wouldn't be putting my thumb on the scale. A remand should be a new hearing, okay? So your position is you agree with that?
I would agree.
Okay, thank you so much. And Ms. Zuschlag? Zuschlag. I was trying too hard, wasn't I?
Yeah. I agree with a remand, but I have a couple of questions. And reading Mr. Wells' letter, he talks about it as a technicality that the people that are within 100 feet were not notified. And I want to be clear that I don't see it as a technicality, that that's a much broader issue, that one of the issues that the neighbors are making is the lack of notification. So I think it would be really helpful to clarify that it's not just a technicality to say, for example, to Tina, you're notified. It's more that really there's a process that, in the neighbor's opinion, has been sort of not followed. The other issue is the EPC format that you have, the presentation. There's really not a great opportunity for the community, meaning the neighbors that live around it, to be able to make a presentation. You're limited to a 2-minute comment.
With the EPC, you mean?
With the EPC, and you can only make a 2-minute comment, and there's really, these issues, some of these require, I mean, honestly, I would hope that the city and consensus planning would be willing to go back and really work with the neighborhood and really talk through the issues before it goes back to EPC. Because the format that EPC is, it's fairly limited, you can't really address the points, and I think Brooke wanted to address some of the points that we wanted to make to you today, because I think it's important that we're forthright and explain some of the issues that we have. So as we all go back and try to communicate better with each other, you're really considering some of the points that are being made.
Thank you.
Yeah.
Thank you so much. Mr. Wells? And Mr. Wells, thank you so much for your candor. I appreciate the fact that you've recognized so early in this process that there was a notice deficiency.
Thank you. We did not learn of the notice deficiency until until the appellate papers were filed. And so that's unfortunate because essentially it means a do-over. And if I could address that for a few moments. As you can tell from the papers that have been filed before you, there aren't many things that the applicants and the appellants agree on. But we agree on this. And just to be clear to the appellants, the reason it's important to the Department of Parks and Recreation and New Mexico United to recognize this is because we don't want a flawed decision any more than anyone else does. In other words, we're interested in a proper process, and due process requires that certain parties receive written notice who did not receive written notice. On the issue of what we should do here today, I would like to suggest that the case should be remanded and the do-over should occur. To our friends who are appellants, I would say this. This is an appeal of a decision that happened on a hearing by the EPC, which is the initial decision maker on these matters. And if we continue with a hearing here to discuss what the EPC did or didn't do right below, it doesn't really matter because the case is going back. There are, as I'm sure the hearing officer knows, New Mexico cases that say when you have a due process flaw, as we have in this case, the decision is void. So there's not anything meaningfully to discuss here today, in our opinion. I'm sorry that so many folks are here to speak to the issues, and I respect their time and their interest, but it doesn't really matter because the case has to go back. All the arguments, all the presentations can be made then. We don't actually know if the EPC is going to make the same decision they did last time. It's a new hearing. It's a do-over. And so I would respectfully submit that on this one thing that all parties before the hearing officer agree on, it makes sense to remand the case, and the EPC notice is posted again, notices are delivered again, and there's a new hearing. It's a do-over, and I would respectfully suggest that it's in everybody's best interest not to waste time doing something here that's not going to matter.
I agree. Ms. Jordy?
I apologize. I have one important thing to bring up in response to Mr. Wells' comments, if I may.
Certainly. Thank you, Mr. Wells. Were you finished, Mr. Wells? Thank you. Ms. Jordy?
The appellants find it entirely problematic that Mr. Wells and Consensus Planning, the city, and United are again stating that the deficiency of notice was not realized until we filed our appeal in early December. In the sworn affidavit that Ms. Jacqueline Fishman of Consensus Planning submitted by Lawrence Wells, in that affidavit, sworn affidavit, she claims that is at the filing of the appeals when she learned of the improper notice. In Appellant's Exhibit C, which we submitted in our supplemental materials, Sandy Zuschlag contacted Ms. Fishman specifically about that issue in October of 2023, well before we filed, saying you have failed to notify these people within the 100-foot area, and they're owed that notice, and Ms. Fishman therefore knew about this issue prior to our appeal. And so this is a huge concern that we have, that the representations being made by the applicants and Ms. Fishman are, they are incorrect. They are deceitful, and we are concerned that this will just again occur lower at the EPC. And we just wanted to bring that to your attention because it is a sworn affidavit, and so I think it's important to just raise that issue.
Okay, thank you, Ms. Jordy. I don't find that there was malicious intent. There's insufficient evidence of that. I think there is a clear notice deficiency, and Mr. Wells recognized that. Certainly, I wish it had been done earlier, but the fact that it's been acknowledged at this point in the game, it makes my job a little easier because I would have remanded it anyway. I don't want to make any findings regarding the substantive merits of this appeal, which I think the intent of any procedural issues would be a meritorious issue that I do not want to comment on. I don't think it's necessary. I don't think it benefits the process to do that. I think a simple remand will allow the EPC to address these issues, including how the EPC deals with the public in its hearings. I don't have any authority to command the EPC to change its rules. Certainly, that's within their authority to do. They can bypass their rules if somebody is asking them to do that for whatever reason, but that's their decision. So I'm going to remand this matter back to the EPC on the one finding that there is a notice deficiency. I'm not going to explain what that notice deficiency is in detail because I'm not convinced that some of these people did not get actual notice. I thought there was at least a few, but that's irrelevant. Just like the intent of consensus planning or anybody else that was involved in this. Those are irrelevant issues. So I will make a finding that there is a notice deficiency and that notice needs to be reaccomplished and that the hearing needs to be held anew as if it never occurred. Okay? Thank you so much, and my apologies for everybody being here for this. I would have done this via email, but there were so many appellants, and I read the letter this morning. There's no way I could have obtained 67 stipulations, via email. Yes.
Just one question is, do we have a sense of the time frame when we talk about a remand? Just so we understand, is it like a month from now? Is it 2 weeks from now? What's the general process?
I will get the remand order out today, perhaps tomorrow, but definitely by tomorrow. And it'll be sent to everybody via email, and I would expect that the planning department would start working on that immediately. So you need to speak with the folks at the planning department because notice has to be reaccomplished. They have to verify notice, and that takes a long time. I don't know. Honestly, I can't answer your question. But the longer it takes would tell me that they are following the rules very closely. So it is a slow process. It's an unfortunate process that needs to reoccur, but it needs to reoccur. Okay? Thank you, folks, so much for your time. Enjoy your weekends. Let's go off the record.
Yeah.